So as I foreshadowed yesterday, what I would really like to do today is talk to you about juries. Now, the very first thing that I'm going to let you know is that there is a whole section devoted to juries in the manual, as you can see that I've pulled up here, and that is section 5. You'll be relieved to know it's a relatively short section if you haven't already had a look at it, and it's got all of the most important things that you need to know about jury events, about what juries are and what they do, what we do type and what we don't type. And it's a really, really critical and useful section. So of course, we've been talking a lot about different sections of the manual over the last few days. I might just reiterate now, the most important sections of the manual really for us are going to be section 4, which is all about witnesses, section 5, all about juries. Section 6 can be useful. It's about what we do and don't type for the different courts. And then section 7, I would say, is the most useful and important of all. And that's all of that stylistic stuff that we've been talking about. Lots of definitions in there as well, obscure terminology and the like. But section 5 is for juries. Now, I imagine just being humans in the world, you probably already know a little bit about juries. And excuse me if you know a lot about them and this is all old news to you, but I might just quickly describe the role of the jury. So of course, when we have a trial, whether it be a criminal trial, as we're going to be focusing on today, or a civil trial, a crucial, if not the most important part of the process is having a jury of the accused person's peers, that is a jury of people randomly selected from the public, to come into the courtroom, to hear the evidence, and to be the judges of the fact. So a lot of the time when you listen to, say, the judge in a case talk about the role of the jury, he will differentiate this important point. The juries are the judges of the fact, and the judge is the judge of, I suppose, the legal theory that underpins everything that happens in the case. He is the judge of the law. So what will generally happen is that for a criminal trial, there will be a jury of 12 jurors randomly selected from the public. And for a civil trial, there will be a jury of usually 6 people randomly selected from the public. Now, a lot of the time, if you have a trial that the lawyers and the judge think is going to go for quite a long time, you might actually have more jurors to start off with. So, for example, I've typed a couple of criminal cases this year. One of them was a drug case. The other one was a sex case. And they knew that it was going to be a trial that went for maybe 2 to 3 weeks. For that reason, what they'll do in that case is they'll actually impanel, and we'll talk about what that means in a second, more than 12 jurors for the criminal case. They might actually select up to 15. And the reason for that is, as you can imagine, over 2 to 3 weeks, it's very likely that you might, say, have a juror who gets sick, or you might have a juror who 3 days into the trial owns up to the fact that, oh, actually they do know one of the witnesses, and you can't have that juror anymore. And in that case, you'll be lucky if the whole jury isn't completely thrown out and you have to start again. But every now and again, they'll get rid of just one juror for a reason like that. So in that case, what will happen is at the end of the trial, because we've got too many jurors, we've got 15, for example, and we need to get down to 12, they will draw a ballot, more or less, to get rid of the extra 3, so that when the jury go to deliberate on their verdict, more things that we'll talk about later, there are only 12 of them going in to deliberate on that. So takeaway message, generally 12 jurors for criminal, generally 6 for civil. Sometimes there can be a couple of extras if it's going to be a really long trial. Now, a really handy part of the manual can be found on page 20. So I'm just going to scroll down a little bit. This is still in section 5, the juries section. And especially as you're coming to grips with the role of the jury and the way that a criminal proceeding proceeds, this flowchart will be of great use to you. It certainly was to me. You can see that the flowchart describes jury selection and trial process. So you can see over here on the left-hand side, we get a description of the steps that the individual jurors go through on the way to actually being involved in the trial. So just very briefly, they'll attend the court for jury service. There'll be a big pool room where all of the jurors are for the day, as I understand it, and they're going to be sent off to various different courtrooms, potentially to be chosen as jurors for those different cases. And there'll be a ballot. So once they've been chosen in that ballot, then they'll go into a particular courtroom, and at that stage, they will be further whittled down to say 12 to 15. At that stage, of the people who have been chosen, they can choose to make an excuse application, which we can see just here. Now, what that means is that a juror might say, I have an excuse. And generally what will happen is the judge will then call that potential juror up to the witness stand and will say, what is your excuse? What is the reason that you can't be involved in this trial? Now, the juror has an option here. Either they can respond verbally with the reason that they don't think they can be involved in the trial, or they can write down their excuse. Now, the reason that they're given the option to write it down is that sometimes a juror's reason for not wanting to participate in a trial can be extremely personal. So, for example, one that you will see all the time is that, say, it is a case that involves the sexual abuse of children. You'll find in those cases there are a lot of jurors who make an excuse application, and a lot of the time the reason that they give the court is, I have kids, I could not be impartial in this case. Or other times you might have people writing down excuses that may be along the lines of, I personally have gone through an experience of sexual abuse in my life. For that reason, I couldn't be impartial in this case. Excuses like that, as you may imagine, almost always are accepted by the court. The judge will say, no worries, you are excused, and they won't have to take part as a juror in the trial. Every now and again, though, you do get someone who tries on a not so worthy excuse. So, for example, someone who says, oh, you know, I don't know, I was thinking about going away on a holiday, and the judge says, well, if it's not an overseas holiday and you don't have it booked, sorry, that's not a good enough excuse. You have to take part in the trial. So that's what the excuse applications is all about, and that often takes quite a lot of time, especially if it's one of those sensitive cases where there's going to be a lot of excuse applications. Now, after that has happened, we should be left with our 12 jurors, and they can all take part in the trial. As they've said, you know, they don't have any commitments. They feel that they can be impartial, so they're well suited to the task. And they don't know anybody who's taking part in the trial, because that's another thing. If a juror knows somebody who is taking part in the trial, say the accused, one of the witnesses, one of the barristers, the judge, then they can't take part in the trial. So everybody who's left is good and ready to go. At this point, the accused person has the opportunity to challenge some of the jurors. So we can see here this section, challenges. What that involves is each individual juror standing up when they're called by the tipstaff or associate. I think it's generally the associate. And the associate will read out that juror's profession. At that point, the juror will walk to the back of the courtroom, will pass by the dock, which is where the accused person is sitting, on the way to the jury box. Now, during that walk, which they refer to as the parade, the accused person has an opportunity to more or less veto the jury member who is passing by. And as you can imagine, the only information that the accused person has about this potential juror is their profession. So it's usually based on that they veto someone. They only have a certain number of challenges or vetoes, and usually one of the lawyers' solicitors who is instructing them will go to the back and stand with the accused person and give them advice on who to challenge or who to veto, and who to let pass. And you'll notice patterns in this. So, for example, if it's, again, if it's a, sorry to keep using this example, but if it's a child sex case, and you have a juror stand up and the associate calls out, this particular person is a teacher, a lot of the time you'll notice the accused person will veto that juror because they believe that it's unlikely that that juror will be able to be impartial in the case, even if the juror has sworn that they are able to be impartial, that is. So that's the challenges. They only get a certain number. And once the challenge is over, we come down here. And at this point in our flowchart, it says jury selection and empanelment. What that just really means is that we have the final number of jurors who are ready to go and ready to be sworn in as the jury. And that's what happens in our next step. All of the jurors have to take either an oath or an affirmation, just as a witness would, just as an interpreter would, saying that they absolutely 100% promise to be impartial and to do their job as best they can during the course of the trial. At that point, we have a jury and we're ready to go. But as you can imagine, there's still going to be a whole bunch of people sitting in the courtroom who haven't been selected to the jury. So remember when they came into the courtroom, there was a sort of big pool of them, and now we've whittled down to 12 or 15. So at this stage, generally His Honour will say, thank you very much to the people who haven't been chosen for the jury. You can now leave and return to the jury pool room where you might be taken off to another case where you could potentially be chosen as a juror. At that point, generally speaking, the judge will ask the jury to leave the courtroom and to go to their special jury room. Now, their special jury room is where they will always retire during adjournments in the case. It's in there that they will deliberate right at the end on their verdict. And in this case, the judge is going to ask them to choose a foreperson. Now, that means they choose somebody who, if the judge needs to address the jury directly at any stage during the proceedings, can speak on behalf of the jury. So generally, when they choose a foreperson and come back into the jury room, there's a special spot in the jury box where they sit, where the foreperson will sit because it's got a microphone in front of it, so they can respond to anything that the judge is saying to the jury directly. The foreperson can be anybody, doesn't matter. They're just chosen by the jury, the other jury members. And we'll talk a little bit more about that later. Okay, so at this point, the jury has been selected, they've been empaneled, as we call it, and we're ready to go, and our trial commences properly. Now, I would like to just quickly go through this side as well, and please do tell me if all of this is absolutely basic to you and you need me to speed it up, because I can absolutely do that as well. But given what we're going to be talking about today, I think it is really important for us to have a bit of an understanding of how a criminal trial proceeds. And generally, a civil trial will follow a similar sort of pattern, especially in terms of jury selection and empanelment. So once our jury is ready to go, typically what will happen is there'll be a short adjournment. So the judge will send them out to get a coffee or something. He might have a little bit of a chat to the lawyers, that is the barristers representing the parties, and then they might go and have a break as well. And when everybody comes back after the adjournment, the trial is officially commencing. And at this point, an arraignment is read. Now, arraignment is a special term. And again, there's a lot of terminology this morning. Don't stress if you can't remember. It's all in the manual and we can go over it and over it. But an arraignment in a legal context means that the charges that have been laid against the accused person are formally read out in court. So what will generally happen is the judge will ask the accused person to stand where they are in the dock at the back of the courtroom. The accused person will stand up, and then the judge will ask his associate, that is his special helper, to stand up and to read out the charges to the accused person. At the end of each charge, the accused person will then respond with guilty or not guilty, and that is the plea, of course, that he is making. Now, if you're in a trial situation and it's gotten to the point where you have a jury and you're ready to start the trial, it is very unlikely that your accused person is going to plead not guilty to the charges. Every now and again, you might get an accused person plead not guilty for, say, one charge and guilty for maybe the rest, but that's pretty rare because usually these things, as I understand it, are worked out before the trial commences. So generally, the lawyers are going to know if they're going to plead not guilty for anything. If they're pleading guilty, then we know we're going to have to go to a trial, of course. So generally, if you ever have to type an arraignment, you know they're probably going to be pleading guilty. At this point, excuse me for just a second. At this point, what happens is the judge will then address the jury. So obviously the jury have been in the room while the arraignment is being read and while the accused person is responding with guilty or not guilty. The judge will then turn to the jury and give them a sort of generic spiel. So the judge's instructions to the jury, we actually don't type, and we'll go through this a little later on. This is just the information that every judge gives to every jury at the start of every trial. So if you ever get to listen to it, you'll notice that for most judges, they literally just read out these instructions and they're the same every single time. Sometimes you'll have a judge who's a bit more animated and who might mix it up a little bit, but generally they will just read out the same thing. And it's usually something along the lines of, ladies and gentlemen of the jury, when you arrived in court today, you might have had a mixture of emotions. Some of you might have been nervous about the task you were going to undertake. Some of you might have been excited. Some of you might have been worried about other commitments you might have, etc., etc., etc. And then what he generally goes on to discuss, he or she, sorry, is the importance of the task that they're about to undertake. Some sort of definitions about law versus fact. So this is the point at which the judge will say to the jury, you are the judges of the fact in the case, and I am the judge of the law. And some other things that they'll just mention every single time. And if you want to know more about that, there's a section in the manual which I'll point you to a little later on. So as I said, we as typists do not type this. We use a certain type of notation, and then we just wait for it to be over. And we'll go over that a little more too. Then as we come down, we can see here that we then move on to the prosecution and defence openings. Now we refer to these as the opening addresses. When we have a criminal trial, the prosecution will always have their opening first. So the prosecution, of course, is the barrister who is representing the Director of Public Prosecutions. They are the barrister who is representing the director who is prosecuting the accused person on behalf of the state of Victoria because they've done something wrong, that is, they've committed a crime against the state, against the community. And as I think I mentioned yesterday, usually the prosecution opening will describe everything that is sort of happening in the case. So it will describe what the charges are, it will describe the particulars of them, and it will give a bit of an intro into why the prosecution believes that the accused is guilty. But it's really only an introduction. They're not trying to really make their argument at this point, because of course the jury hasn't seen any evidence. So it's really just to introduce them to the particulars of the case, and it can go for a really long time. So particularly for complex cases, I think I mentioned, you know, the prosecution opening could be upwards of an hour. Then what happens is the defence barrister is given the opportunity to respond. So he can give a reply opening address. And this one tends to be much, much, much shorter because, of course, at this stage, the jury has already heard sort of everything they need to know about the particulars of the case. So generally, the defence barrister will get up and will say, you've heard what the prosecutor had to say. We will be telling you this, this, and this throughout the case, which, you know, at the end, should lead you to find the particular person not guilty. And it might be just 15 minutes or so, and then the defence barrister will sit down. Again, in a criminal trial, we do not type these openings. And this is something we'll continue to reiterate because it's hard to keep in our head what we do and don't type. But in a criminal trial, we do not type the prosecution or defence opening addresses. We use a macro instead. However, for civil trials, we do generally type the opening addresses from both parties, but we also have a macro to lead into it. And again, we'll go over this many more times before we're finished, so don't stress. At this point, we can move on to the evidence. Now, bear in mind, we've gone through a lot of steps already. Not all of this, of course, will necessarily happen in one day. So generally, our left-hand column, our jury selection process will happen in the course of one day. And the audio that I nominated in the email that I sent you, the first segment, is a whole day's worth of jury empanelment, more or less, and then the first few phases of the trial over here. But of course, once a trial has begun, as we said before, it can go from anywhere for a few days up to maybe a few weeks. So this is obviously the compacted version. But in any case, after the prosecution and defence openings, as we said, we have the evidence. Now, the evidence can take many forms. The evidence will generally be witness evidence. So as we've said, the prosecution barrister will call a number of witnesses that they think support their case. And the defence barrister will also call potentially a number of witnesses that it thinks support its case. But of course, just because we have witnesses from different sides of the struggle doesn't mean that both sides can't ask questions of all the witnesses. So for every witness, regardless of whether or not it's a prosecution witness or a defence witness, we'll go through all of those phases of examination that we've discussed: the evidence in chief, the cross-examination, and the re-examination. All that changes is which barrister starts first. So if it's a prosecution witness, the evidence in chief will be given by the prosecution barrister. If it's a defence witness, generally the defence barrister will give the examination in chief. Another type of evidence that we've also spoken about, of course, is exhibits. Generally, during the course of a witness's evidence, or sometimes during legal discussion, as we've spoken about, exhibits will be tendered to the court, and these are almost always tangible things. So we've said before, sometimes evidence might be, for example, a piece of clothing or some other object that's important to the case. But sometimes you might have something, for example, like pre-recorded evidence being tendered to the court as an exhibit. Sometimes pre-recorded evidence will be shown to the court, so the jury will watch an interview, for example, of a witness that has been pre-recorded, and then that tape that has been played will be tendered as an exhibit to the court. So when we're talking about evidence, generally we're talking about witness evidence that can either be given live in court or live from a remote facility, or it could be witness evidence that has been pre-recorded prior to the commencement of the trial, or we could just be talking about evidence in terms of exhibits, that is, objects that are tendered to the court and are important to the running of the case. And of course, all of the evidence really is for the benefit of the jury, because as we said before, the jury are in the courtroom to be the judges of the fact. So they listen to all of the evidence. Generally, by the end of the matter, they have a massive fat folder with all of their jury documents inside. You know, they might have maps, they might have transcripts, they might have all sorts of things in their jury folder, which is evidence that they will consider when they eventually retire to deliberate on their verdict. And then based on that, the judge will give his sentence. So after all the evidence has been given and tendered, we then move to the closing addresses. So this is a bit like the opening addresses, but it's just to close the case. The prosecution barrister will get up and give a big speech about why you should find the accused person guilty, and the defence barrister will then get up and do a similar thing in terms of why you should find them not guilty. And again, for a criminal trial, we do not type closing addresses. For a civil trial, we do type them. And again, I'll take you through the macros and the notation that we use for criminal versus civil. At this point, the judge gives a charge to the jury. And what that means is the judge makes a speech to the jury about the task that they now need to undertake, which is to retire to the jury room, to deliberate, consider the evidence, and then come up with a verdict. And during the process of the charge, every now and again, one or more jury members might have questions that they want clarified. And in fact, jury questions can actually occur at any point during the trial, but we treat them a little differently when it's at the end. Sometimes as well, if we move down to jury redirection, the barristers will not agree with something that the judge has said in their charge or their speech to the jury about their task. If that's the case, there'll generally be some legal discussion in the absence of the jury. And once they've hashed it all out, the jury will come back in, and the judge, if he agrees with what the barristers have said, will officially redirect the jury. So we'll say, hey, you know what I just said? Actually, I have to add something to that. Consider yourselves redirected. Then you can see we come down here to jury ballot. This doesn't always take place. This is what we were referring to before when we were speaking about, say, juries of 15 people being whittled down to 12 people. So if we've got too many jury members, then we will have a ballot at the end to get it down to the appropriate number. And then, almost finally, the jury will retire to consider their verdict, and then we'll come back into the courtroom with the verdict of guilty or not guilty, or sometimes a hung jury, which is something I personally have never had to deal with. And then at that point, the jury's job is over and they are discharged. So thank you for bearing with me through that description, but I just wanted to introduce the flow of the criminal trial, because today we're going to be talking about a lot of these different phases, and it can be a little overwhelming if you don't sort of have a broader overview or a bigger picture. So just remember, this is page 20 of the manual, and we'll refer to it a number of times throughout the morning. Okay. So what I'm going to do is I'm going to show you some of the different things that we do when we're typing different phases of a trial, and particularly phases that involve the jury. And what I'm going to do first is go through how we impanel a jury. Now, if we come back to our manual and scroll down a little bit, you can see on pages 21 and 22, we have a description of what is included in a jury empanelment for the county court and what is included in a jury empanelment for the Supreme Court. Now, the reason that I take you to that, first of all, is because on these pages, it actually gives you a description of what empanelment means for our purposes as typists. So for the county court, which is where we've been focusing most of our attention this week, we can see over here on the right-hand side of that page 21, a little description of what empanelment includes. So we have a particular notation that we use for empanelment, and it's really handy to have this page open because it tells you everything that is included under that little notation. You can also see just above the empanelment, we can see what we sort of described before. So say this was a county court criminal matter, we can see that generally before the trial commences, there'll be a short adjournment after the jury has been so generally the jury will be brought into the courtroom, after a short adjournment. And then we'll have the arraignment. So that's what we were talking about up here. So, but every now and again, before a jury is impaneled, we will also have an arraignment. So we've got the arraignment over here, but sometimes as well, what will happen is the judge will bring in the whole pool of jury members. And because of the nature of the case, for example, if it's of a particularly sensitive nature, they'll actually arraign the accused over this side down here, just before the selection of the jury in the courtroom, so that the jury know what type of case it is, because you're much more likely to hang on to your jury members if they know what they're getting into. Whereas if you arraign an accused only over here, once you've already got a jury and they don't know what the case is about, then you might suddenly have a whole bunch of jurors going, oh, actually, I totally can't be impartial in this. I can't be a part of the jury. So if we come back down here, you can see that during the short adjournment, generally that big pool of jurors will be brought into the courtroom and we will arraign the accused. So I'm just going to run us through these steps. We can see here that we do not transcribe His Honour saying to the associate, I now authorise my associate to read out the charges and arraign the accused. We will always transcribe the bit where he says, please arraign the accused, but the following little bit where he says, I authorize my associate, etc., we do not transcribe. Now you can see there's a little note on that here. Don't worry too much if you don't really understand how that works just yet, because once you start watching impanelments, you'll come to know that language that they use, that I now authorize my associate, and that's automatically a clue to you as a typist that we're not going to type this. What then follows is the arraignment. So that includes the charge that we can see here, and also the plea given by the accused person. Oh, sorry, I'm just getting messages from people here. Now, as you can see here in our example, we do include the arraignment. So I'm just going to show you how to do that now. We're going to come over here. Okay. And just before I do, just a little caveat, I think. I'm going to run you through today everything to do with juries. I'm going to show you the macros that we use for the impanelment. I'm going to show you, as I'm just about to, how we do the arraignment. But just keep in mind, actually as at-home typists, it is very rare that you will be called upon to do a jury impanelment and arraignment. And the reason for that is that impanelments a lot of the time involve a lot of watching and a lot of keeping track and not a lot of typing. As I said to you before, we just use particular notation for this long process of impanelment. And then the arraignment is very short, and then we might move straight into opening addresses, which we don't type for criminal matters. So it's not worth the time of the at-home typists to be doing an impanelment because you're not going to make any money from it. So generally, if there is an impanelment at the start of a trial, it will be allocated to an in-office typist. But the reason that I'm going to run you through all of this is because it's really, really important, I think, to have a knowledge of what goes on in a trial, and just in case, for whatever reason, you are called upon to do an impanelment and arraignment. Beautiful. Just before I show you how to do the arraignment in Microsoft Word, that was a lot of information. Does anyone have any questions at this stage? Not by the looks of it. Okay, no worries. Again, just let me know if I'm too 101 for you, or if, on the other hand, I'm galloping ahead and you need me to go back or reiterate or point you to places in the manual, anything like that. Because we have microphones on mute today, sometimes I forget that I'm not just talking to myself, and I might forget to ask you if you have any questions along the way. So just stop me, just sing out. Okay, so arraignments. So in our little example over here, we can see what the arraignment looks like. It's got the little charge, and then it's got the accused plea right underneath. Now, we have a macro for this. So for a criminal matter, of course, we're going to come into Microsoft Word under the VGRS ribbon, and we're going to come across here to the arraignment button. We click on that. And you can see here that we have a box to put the accused person's name, and then we have a box to put the charges. And actually, say the accused is Joe Anthony Bloggs, to use my constant Bloggs example, and say the first charge was, say it was rape. You can see as soon as I put a charge in there, it automatically comes up with a second box to put subsequent charges in. Now, say for example, the second charge was arson. We actually don't need a full stop. The second charge was arson, and then they read out a number of charges, but say charges 3, 4, and 5 were all either rape or arson. At that point, we don't need to keep typing in here rape and arson and so on and so forth. If we have more than one charge for the same type of offence, we come over here to the box on the right-hand side and we click the appropriate number of charges. So say, for example, charges 1, 4, and 7 were rape charges, then I would click 3. And say 2, 3, 5, and 6 were arson charges, then I would click 4 charges for arson. And you can see then what happens down the bottom is that we have a box for each of the charges. And it's actually come up with 10 because I've got some boxes here, but it doesn't matter. We only fill out as many as we have charges. So say, for example, the accused pled not guilty to all of those charges. It's very simple. We can just go not guilty to all charges, and it automatically highlights it in green. Or say, for example, this was before a trial and they pled guilty to everything. We can do the same. It all comes up in red. Don't worry if you have too many charges down the bottom. Once we generate the macro, it will just say the accused pled guilty or the accused pled not guilty. So it's not as though you'll have 7 charges up the top and then 10 down the bottom that they've pled to. It'll just give you a generic plea. Now, the other thing, of course, to keep in mind is that every now and again, you will get an accused pleading guilty to, say, 1 charge and not guilty to all the rest. So say we had 1 charge of rape and 4 of arson. What might happen is they might plead not guilty to the rape and then guilty to all of the rest. Actually, we can do NA for the ones that aren't relevant. There we go. So we can see at that point, if we need to specify which specific charges they've pled guilty and not guilty to, we can come down here and elect whether it's guilty or not guilty or not apparent if we've got too many charges. And then at that point, we could submit. Every now and again, though, you might be typing for a trial that has more than 1 accused person. I did one of these recently. It was a massive drug importation trial, and there were 4 different accused. So when we did the arraignment at the start, we had to do 4 separate arraignments, but we do it all within the 1 macro. So you can see down here, we have another button for add another accused. And at that point, we come up with another box. And we can do 3, and we can do 4. I've never tested how many you can do, but it would be a rare trial indeed where you had more than 4 in the courtroom. So I'm just going to press submit for now, and hopefully it will just do my first one. Okay. All right, and now my computer is just going to throw a tantrum. Hopefully we'll do it. Nope, it does not like that. Okay, we'll just give it a second. In any case, what it should do, here we go. Beautiful. Now, I'm actually going to jump back into it and just start it again. Because I pressed on all of the other accused, it gave me a very ugly looking macro. So if we just had the one, say again, Joe Anthony Bloggs, we had 1 charge of rape, for example, and arson 3. And I'm going to go not guilty for the first and guilty, not guilty for the first and guilty for the rest, for example. Of course, if this were the plea, then the trial would just be about the one that they've pled not guilty to, obviously. Submit. And this is what it looks like. This is the macro that's generated. We can see here that they give charge up the top. There's 1 for rape and there's 3 for arson. And then we can see down the bottom, the accused pleaded not guilty to charge 1 and guilty to charges 2, 3, 4, and 5. And then in the merge, of course, it would end up looking slightly different. It would end up looking something more like this that we see here in the example for the county court. Now, you may be asking yourself, okay, no worries. Am I always going to know what the charges are? The answer is yes, but with a bit of a proviso. So obviously part of the official arraignment is the judge's associate standing up in court in front of the jury and the accused and the lawyers and everybody and saying, here are the charges, and reading them out, and then the accused pleading guilty or not guilty. However, sometimes what will be read out for the charges are these very long, convoluted charges with lots of particulars. So for example, instead of arson, you might have, and on this day it is charged that you went into a house in Blairgowrie and in the presence of 4 other people, I don't know, you did light a match and set a fire and etc., etc., etc. And that's just the 1 charge. I mean, obviously, if they'd said that, you would hear set a fire and you'd think, oh, this is probably going to be arson. But it can be even more confusingly put than that. How do we know then what to put into that tiny little box in the arraignment? How do we know? There are a couple of ways that we can know. And the first one is sometimes the parties will send us what we call an indictment. And excuse me again if you already know what an indictment is, but it's generally something that is a document that is generated by the Office of Public Prosecutions that has the official list of charges on it. And sometimes, very handily, they send that through to us. Now, I'm going to show you where we can find that in our system, because if you are ever in charge of an arraignment, which hopefully you won't be as an at-home typist, it's really, really handy to know where this is kept, because generally it will give you a list of the charges, and then you just have to listen through to what the associate says and make sure that it matches up with your document. The other really great reason, the other really great use of an indictment is a lot of the time it will have a witness list on it. So if you wanted to fill out your glossary with better information, you could go in there and see how all of the names are spelt. So if you wanted to find the indictment, where we keep it is in the transcript drive. And then say we were doing a county court matter and say it was criminal. And I'm just going to show you an example of one that I did earlier this year because I know it has an indictment. So we were to come into R and into Ramasamy. This is the drug case that I was talking about previously with 3 or 4 accused people. And then once you get to this point in the folders for any case, you'll see that there's generally a folder labeled reference documents. Now, if we come into there, we can see 2 files in here. So let's just open them up to see what they are. Here's the first. And we can see, huzzah, we have an indictment. Fantastic. I'm just going to see what that other document is. The other document is also an indictment. And I think it's just a direct copy. It's good to make sure if you've got a number of indictments that you are looking at the most recent one. So I just mentioned that to you now because sometimes you might have an original indictment with a couple of charges and then they might say, oh, actually, we're only going to charge them with one thing. And they might generate a new indictment with a new indictment number. So when you're doing the arraignment, you just have to make sure you're working with the right indictment. So for example, this particular case, we had the indictment for this gentleman, Mr. Subramanian, and then we had a list of witnesses that were going to be called in the case, and it was a big one. And then we had another indictment for the other individuals, Ramasamy, Silvaguru, and Tustahir, who are also involved in this case. But I'm going to come back to Subramanian because he just has one charge. You can see here that we have one charge and it's import a commercial quantity of a border controlled drug. And then we've got contrary to subsection, et cetera, et cetera. Now I would look at this and provided they read out more or less the same thing in court, I would pop into our macro, import a commercial quantity of a border controlled drug. And I'd leave out this bit down here. Because again, they know what the charge is. So when they're reading our transcript, unless our arraignment macro is incredibly wrong, they're not going to be too bothered about whether or not contrary to subsection 307, etc. is included. They just want to know what the charge proper is. If I come back here to the other gentleman, you can see it's all the same charge for them. Beautiful. We don't have anything else for this particular case. So this is a really, really good resource for us, not only for the arraignment, but as you can see, for witness names. So actually for this case, I was in charge of the impanelment, the arraignment, and the openings at the start of the trial. And so during some of that downtime, when I wasn't typing on other things, I actually went through and typed all of these witness names into the glossary because it meant that when we then went on to type the trial, most of the time we didn't have to guess about the names and everybody could use the same spellings. So just to reiterate, if you're looking for an indictment or potentially other documents that might be helpful for spellings, we come into the transcript drive, the T drive, into the appropriate court, into civil or criminal, so criminal for this one, into the appropriate letter. And then once we jump into our case, we can see that there's almost always a reference docs folder, and hopefully there'll be an indictment in there if we're lucky. However, what happens if we don't have an indictment? This happens all the time. If we don't have an indictment, we actually have a number of resources that we can use. And these are the resources that I emailed you this morning. One of them is called, I'll just get it up. One of them is called arraignment charges, and it looks like this. Okay. And what it actually gives us is a whole list of different offences with a definition. And so you can see in the definition, it gives us different ways of formulating the offence in speech. So these are some of the ways that you might hear them referred to in the court. This is handy, but to be honest, I actually find the other document that I sent through to you handier, and that's the one that's labelled arraignments in real language, and it looks like this. And you can see here that for the different offences, it has given us a whole host of different ways of referring to these offences in speech. And at the end, it'll tell us what that equates to in terms of the charges. So say, for example, you heard this long convoluted charge read out by the associate. So-and-so attempted to enter a building in Blairgowrie with the intent to commit an offence involving an assault to a person therein and had with him an offensive weapon, namely an iron bar, a knife and liquid-filled syringe. You would come in here and you would see attempted aggravated burglary. A lot of the time, of course, you might hear some keywords in the arraignment. You can jump into this document, go Control F and search for some of the words, and that might help you to find the bit that corresponds to it the best. It's a bit of an imprecise science when it comes to typists doing the arraignment, but again, we just do our very best with the resources we have. If the parties have a problem with it, they will get back to us and let us know that we need to change it. But I spoke to a TC who had been working here for 5 years, and she said in that time she had never had a transcript sent back with a request to change the arraignment. So I think for the parties, as long as it's vaguely correct, it's actually not that important to them. But we still do our best, of course. So those are those two documents, and that's how we do an arraignment. Once we've done that, once we've listened to the charges and the plea, and we've generated the macro, we're done with the arraignment. Does anyone have any questions on that at this stage? I have to admit to you, I've just been bought a coffee, ladies. Excuse me, just looking towards the door. Does anyone have any questions on arraignments?
No, I don't.
No. Perfect. Okay, wonderful. So I'm going to move on. If we come back to our little flow chart, oh, actually I might come down here, sorry. If we come down to our county court example, we can see that after our arraignment, we're going to move on to the empanelment. And you can see this little notation here. At this stage, a jury of 12 was empaneled, and it gives us a little list of everything that is involved in the empanelment. So a lot of the time when we're talking about jury events early in the trial, they'll just be talking about the empanelment. So it's really good to know what that includes. And we can see here it includes the judge addressing the panel about the importance of the task that they may be undertaking, the jury panel members announcing present or excuse, jury excuses, jury member selection and challenges, so that bit where they walk past the accused and he can choose to veto them. The rest of the rejected jury members leaving the courtroom, the jury being sworn and affirmed, the judge describing the fact that they have to go and choose a foreperson, and the jury leaving to select a foreperson. So we can see up here again that almost all of this here, so from selection of jury in the courtroom down to foreperson selected, is all encompassed in this one little notation of, at this stage, a jury of 12 was empaneled. So I'm just going to show you the way that we do that. And it's just manual. The way that we go about it is, say we had just had an arraignment, so I might get my arraignment back for the sake of it, and then we are going to move on to our empanelment. We would leave one space, we would do a tab in, and then we would type at this stage, a jury of 12 was impaneled. Full stop, close bracket. There we go, and we can see that here as well. Beautiful. Now, this particular notation is another one that you can find in the manual in the inner margin notation section. And I just bring this up again because we briefly looked at it yesterday, but it's one of those tricky ones where there's a lot of information but not a lot of elaboration. So I just want to draw your attention to it. Here we go. So you might remember this list on page 85 of the manual of inner margin examples. Now, the reason that they're called that is all of these bracketed examples given here are preceded by one tab in from the side of the page. So even though you can't really see it here, when we've done at this stage a jury of 12 was impaneled in our document, we've tabbed in once and then we've put the notation. And that's why it's referred to as inner margin notation or examples. So if we come down here, we can see this is one of the ones that is listed in there. At this stage a jury of 12 was impaneled. So as you can imagine, you might type this notation and then the impanelment could go for an hour, sometimes more, sometimes less. So again, this is the reason why we don't typically get at-home typists to do the impanelments if we can avoid it. Now, there is a little peculiarity with impanelment. If we come back here to juries, and back down to our little example, we can see that at this stage a jury of 12 was impaneled also includes the jury leaving to select a foreperson and returning. However, there is an exception to that. If the jury leaves the courtroom to select a foreperson, and while the judge and the barristers are waiting in the courtroom for them to come back, they have some discussion, so they literally say anything to each other, we have to transcribe that discussion. And if that is the case, then we would do what is being done here. So if the jury had left the court to select a foreperson, and while they were out, the judge and the barristers literally just sat there in the courtroom, not saying anything, and then the jury came back in with the foreperson, we would just leave it at this stage a jury of 12 was impaneled. But if the jury leave the courtroom, and while they're selecting their foreperson, the judge and the barristers have a big old chat about whatever, it might be administrative, it might be legal, it might be having a joke together, then we have to, below the impanelment notation, do another one that says we insert the time, the jury left the court to select a foreperson, and then below that, we type all of the discussion that occurs between the judge and the lawyers. And then when the jury come back in, we have to use another inner margin example. We insert the time, the jury entered the courtroom. We can't actually see it there, but I'll show you in the inner margin examples in a second. All right. So that's just that distinction there. Any discussion while the jury are out selecting a foreperson, then we have to use the, at say 11:46 a.m., the jury left the court to select a foreperson, type the discussion, and then use the other notation at 11:51, they entered the courtroom having selected a foreperson. But if while they're out selecting a foreperson, nothing is said in the courtroom, then we just leave it at a jury of 12 was impaneled. And if we come back again to inner margin examples, then we can see, if we weren't sure of how to type those examples because they're partially covered by little boxes in our previous example, we can see, we come down here, for example, at 2:45 p.m, the jury left the court to select a foreperson. We just put in the appropriate time, and the one coming back at 2:45 p.m, the jury entered the court having selected a foreperson. That's where to look for those if you're ever wondering. Coming back to juries, we can see that after we've had the impanelment and after we have had the selection of a foreperson, what will then happen is the formal appearances. Now, when I say formal appearances, I mean the bit where the prosecution barrister will stand up and will say, Your Honour, if it please the court, I appear on behalf of the prosecution, or something to that effect. And then the defence lawyer will stand up and say, "May it please the court, Your Honour, I appear on behalf of the accused man," or "I appear on behalf of the defence." We refer to those as formal appearances. And that's the point at which we start typing after the impanelment. If we haven't had any discussion previous, that is, while they've been selecting a foreperson. So it's just good to note formal appearances when the lawyers formally introduce themselves after a jury has been impaneled. There we go. Okay. So if I come back up to my little flow chart, we can see that after we've had that arraignment and after the jury has been impaneled, and after we've had those formal appearances we just discussed, then generally we'll move on to the judge's instructions to the jury. Now, as I said before, this is that sort of pre-prepared spiel that every judge just reads out of a little book, and it's usually exactly the same judge. You'll come to recognise it very quickly. Again, we don't type out what they say in those instructions. We use a specific notation instead, and I'm going to show it to you. So we've had the impanelment and we've had Mr. Prosecution say, may it please, Your Honour, I appear for the prosecution. Oh, and you can see here that for some reason my formatting is gone, so I'm going to highlight this, come to transcript and click fix format, like we spoke about before. Okay. And then Mr. Defence says, Your Honour, I appear for the defence. Then His Honour launches straight into his instructions to the jury. So, members of the jury, when you appeared today, when you came to court today, you might have been nervous, you might have been excited, blah, blah, blah. What we do instead of typing that out is we do a tab stroke in, we do an open bracket, and we type His Honour's or Her Honour's directions to the jury. Full stop, close bracket. Now, it's good to keep in mind that everything we've spoken about up until now sometimes can change a little bit in terms of the order. And that's because judges are really cruel to typists and they like to keep us on our toes. So again, hopefully this won't be an issue for you because ideally speaking, you won't be typing a lot of impanelments. But every now and again, a judge will get tricky and will do things out of order. Which is a real bummer for us because, for example, our impanelment notation, we really only should use once. But it can be really difficult if the judge over here does part of the impanelment and then does some instructions to the jury and then does another part of the impanelment. And then we have the formal appearances and it's all higgledy-piggledy. Again, you won't have to worry about that. But the reason I mention it is His Honour's directions to the jury is a notation that we can use several times if we need to, if they mix up the order of the proceedings. So say he took his pre-prepared spiel and divided it into 3 bits. It can be difficult if you haven't typed them before to know which is pre-prepared, but usually they read it, so it's fairly obvious. We can use this, say, 2 or 3 times throughout this part of a trial. Whereas the impanelment notation up here, we can only use the once, even if they muck up the order of things, and then you have to get a bit creative as a typist, unfortunately. So say His Honour then talks through his pre-prepared spiel, that can go for ages. So a lot of the time, you know, you could be maybe half an hour or even more with His Honour's directions to the jury. And then, as you can see over here, what follows is the openings from the prosecution and defence. But what will generally happen before then, because the directions to the jury are so long, is that there'll be maybe a short adjournment. So let's say that happened here. Let's say at the end of his instructions to the jury, Mr. Prosecutor said, Your Honour, I note the time, which is something they say all the time to wind the judge up. And His Honour said, yes, let's take a 10-minute break. At this stage, of course, the judge will rise and he will bow and the tipstaff will say, this court is temporarily adjourned. So I'm going to come up to my adjournments. I'm going to do a short adjournment. Oh, actually, I'm not going to do that just yet. I've forgotten a step. His Honour has said, yes, let's take a 10-minute break. Members of the jury, I'll see you soon. What will then happen at this point is the jury will leave the jury box and retire to the jury room, and from there they might go out and get a coffee or something. And the reason that I mention that is because we need to make a note of it in the transcript every time the jury leave or enter the court. And they always leave the court before an adjournment. These are things we'll go over again soon, but I just want to make that really clear as many times as I can. Before an adjournment, the jury always leave the court, and then they're brought back in after the end of the adjournment by the judge. So say here, because we have a jury at this stage, they've been impaneled up the top, we're about to take a 10-minute break, means we need to indicate in the transcript that the jury are leaving the courtroom. So generally they'll all stand up in the jury box and they'll start to leave. What we would do at this stage is come up to our VGRS Word Macros ribbon. We would come across to jury events, which is one of the little sections we haven't looked at yet. And you can see here we have a number of different jury events. Now for this particular one, the jury is leaving the courtroom, so we're going to press jury out. And we're going to put the time that they left the courtroom in here. So let's say it was 11:43, we'd leave that there and we press OK. And you can see we have a macro that tells us that the jury has left the court. It's really, really important for us to remember jury macros, because a lot of the time what happens next, say the discussion, in the merge will then start on a new page. So we need to have those macros in there to let the computer system know that a new page is going to be needed. Okay, so at this stage, the jury has left the courtroom, so His Honour says, "See you soon," to the barristers. He gets up, he bows, he leaves. The tipstaff says, "This courtroom is temporarily adjourned." So we're going to come into the adjournments macro, and we're going to press short adjournment because we know it's only 10 minutes. So here we go, short adjournment. Great. To say at this stage, we've had our 10-minute break, and the lawyers are all back in the courtroom ready to go again. The jury won't be in there because they need to be formally brought in by the judge, but the lawyers are all in there ready to go. There's a knock in the courtroom by the tipstaff, which means that the judge is about to come in. The judge comes in, bows to everybody and sits down and says, "Bring the jury back in, please." At this point, of course, we need to indicate in the transcript that the jury are going to re-enter the courtroom. So when they start filing in, when we can see them filing into the court, we come back up to jury events, and we're going to press on jury in this time because they're coming into the court. And it was about 10 minutes since last time, so let's say it's 11:55 a.m. Press OK, and you can see here we have our macro for the jury entered the court. So if we're following our general procedure for the start of a trial, at this point, we would probably be up to the prosecution and defence openings. Every now and again, His Honour might go on for so long with the directions to the jury that after a short adjournment, he might just pick right up again. He might go all day if it's the afternoon, but generally it's not so long. So then you might have the prosecution giving his opening address. Because as we said, the prosecution always opens the case with his address. Now, you might remember before that I mentioned the opening address is where the prosecution gives more or less a big description of all of the particulars of the case. And then the defence is given a very short right of reply in which he gives a brief outline of where the defence is going to be going. Now, you will remember also that I said before that in criminal matters, we do not type the opening addresses for either the prosecution or the defence. We do in civil, we do not in criminal. As a starting typist, I did once type the opening addresses and it was a waste of everybody's time. So if there's one thing to keep in your mind, it's do not type the opening addresses for criminal matters. If you wanted to remind yourself of that, I'm going to take you to another point in the manual that we mentioned earlier this week, and that's in section 6, which gives us a description of each court that we mostly deal with and what we do and do not type. So you might remember it's in section 6. Let me just find you the page. Here we go. So section 6 on page 34 for the County Court gives you a list of everything that might happen within the matter and whether or not we transcribe it. So if we come down, down, we can see some things that we've already spoken about today. We do not type, and we know that already. So for example, the jury empanelment we were speaking about before, and that's the one that we used the notation jury, at this stage a jury of 12 was empaneled. You can see over here we say do not transcribe. We just use the margin heading. Jury excuses, we don't transcribe. We've spoken about that. Jury not selected, we don't transcribe that. Jury foreperson, we don't transcribe unless there is discussion in the absence of the jury. We use the margin heading. We've spoken about all of those things. And likewise, if we come further down to opening addresses, we can see it's only as requested. And we do type discussion that might intersperse. So as we said before, the prosecution could give an opening for, say, a good hour. And if during that the judge interrupts and says, oh, but what about this? I thought you were going to talk about that. And the prosecutor says, oh, no, I wasn't going to talk about that. Do you mind if I keep going with my address? And the judge says, yeah, no worries. Then we would come out of the notation that I'm about to show you. We type the discussion and then we come back into the notation. That's what it means here when it says all discussion. And you can see that we use a margin heading when we're not transcribing it in full. Now, I have only typed a criminal opening perhaps a couple of times during my time at EPIC, and they were for high profile cases. So sometimes if it's particularly high profile, for example, there might be a request for us to transcribe the opening addresses, but you almost never do, and you can just assume that you will not be typing it. If there has been a request, the TCs, the transcript coordinators, will let you know. So as far as you're concerned, if we have a criminal matter, do not transcribe the opening addresses from either prosecution or defence. Okay, I'm going to show you now which margin example we use. Okay. So we've entered the court, and His Honour is going to say, Mr. Prosecutor, are you ready to open your case? And Mr. Prosecutor says, yes, thank you, Your Honour. At this stage, what will happen is he will turn to the jury and will say, members of the jury, I don't know, thank you for listening to me today. I'm going to tell you all about the case, and here it is, and then it'll go and go and go. And so at that point, you know it's time to use the address macro. So if we come up here to court events, so again, under our VGRS ribbon, court events, and we're going to come over here, we can see we've already spoken about some of these court events. So the in-camera or closed court macro we've already been introduced to. We've spoken a little bit about voir dires as well. You can see there's also a macro up here for address not typed in full, which is the one we're going to be looking at, and also a macro for address when it's typed in full. So we'd be using that if there had been a request, for example, for the whole opening to be transcribed. And you can see here we also have a macro for the end of the address if we have transcribed it in full. But for our purposes, this is just a normal criminal trial. We're not going to transcribe the openings. So we're going to click J, address, not typed in full, and we're going to put in the counsel's name. So it's the prosecutor. Of course, we would put in his surname, not Mr. Prosecutor. And then we would click OK. And we can see here that it gives us a macro. Mr. Prosecutor, say his name's Mr. Smith. Mr. Smith was heard to address the jury. Now, say, for example, we did have some discussion in there. Say His Honour at one point said, what are you talking about? And Mr. Prosecutor said, can I continue? Which would be a very rude exchange. You'd almost never get something so rude in the courtroom. Then we would type that discussion, and then we would again come back into court events and pop in the address macro again. and just pick right up with it. So this is another one that you can come in and out of. It's nicest if you don't, because it kind of looks messy, but these are the instructions that VGRS give us, so that's what we're going to do. Okay. But say there wasn't any discussion, say we had the address to the jury and he spoke for an hour and described the case, then what's going to happen is His Honour is going to say, "Thank you, Mr. Prosecutor." And a lot of the time we'll just say, "Mr. Defence," and then Mr. Defence will say, "Thank you, Your Honour." This is literally how it happens almost every time. And then it's time for the defence lawyer to turn to the jury and to address them on sort of his side of things, generally for maybe 15 minutes or so, if he's lucky. You have judges who really crack down on timing in that way. So we're going to do exactly the same thing for the defence lawyer. We're going to come up to our VGRS ribbon, go to court events. We're going to press on address, not typed in full because this is criminal. We're going to type his name into the box, press OK, and you can see here we now have our macro for the defence opening address. Okay. So that is opening addresses. All right, so at this stage, we've gone through a number of steps so far. Does anyone have any questions just at this point before we keep going? Not by the sounds of it. Okay, no worries. I'm just going to look over to my schedule of what I'm trying to get through this morning, just because I note that it's 12 o'clock. Okay, beautiful. What I'm going to try and do is only talk for the next 15 to 20 minutes and then give us 10 minutes at the end, just to have a bit of a watch through, hopefully some of the footage that you were able to download for that little first segment that I sent you last night for the Adara case. That first segment was a whole day's worth of footage, so I will not be offended if you did not download it all. But it's good to even just look through the transcript for that day, because we have this whole process in there, and it will make the things I'm saying to you a whole lot more tangible when you can watch them going on in the courtroom. So it's something that you could flick through so you don't have to watch a whole day's worth of footage. I'm going to try and give you maybe 10 or 15 minutes at the end to do that so it doesn't impinge on your lunch break. And up until then, we'll just keep going through the course of events in the trial. So now we've had the prosecution and defence openings, and at this stage, of course, we would progress then to the evidence. Now, we've spent the last couple of days talking about witness evidence with an interpreter, how we use macros for exhibits when exhibits attended to the court. So that's something that we probably don't need to talk about right now. Instead, what I might do, because the evidence takes up most of the time in a trial, I'm going to come back over and we're going to abandon our example for a second and just start another blank Word document. Because at this stage, having gone through the jury empanelment, the arraignment, the opening addresses, we've really touched on the most important notations and events that we need to talk about for the start of the trial before evidence begins. So I'd just like to go a little more in depth into some jury events that we haven't perhaps spoken about. So I'm going to jump back into the VGRS ribbon, the criminal ribbon, and I'm going to press on jury events again. Now, we've already spoken about jury in and jury out. And of course, we need to make a note in the transcript every time the jury leave and enter the courtroom after they've been empaneled. So after we've had that whole empanelment process where the jury of 12 is selected and then they're sworn in and they're ready to go, after that point, every time the jury is asked to shoof out and shoof back in by the judge, we need to note it in the transcript. And we've already spoken about that. When they come into the court, we use jury in and we pop the time in. And when they leave the courtroom, we use jury out and we also pop the time in. One thing to just keep in mind in terms of the timing is that it's generally ideal if the time that we input matches up with the time that is on our log. So we might remember that our log will give us generally a running list of times and when important-ish things have happened. And if the monitor is on the ball, they should always include jury events in the log. So ideally, they should be put in say, at 11:48, jury out, or at 12:05, jury in. And so when you're popping in the time, just have a little look on your log as well, just to make sure that it matches up. It's not the end of the world if the monitor has got it a little bit wrong, excuse me, but it's good just to try and match it up if you can. All right, so that's jury in and jury out. And of course, we have to remember that the jury always leaves the court before an adjournment. And then when the adjournment finishes, the judge and the lawyers will appear in the courtroom first, and then the jury will be brought back in. So that's when we use our jury in macro. All right, okie doke. What we have down here are some more macros. I'm going to show you this first one for jury absent. You can see it comes up as in the absence of the jury. If we come back up and click on jury absent upon resuming, you can see that it comes up with this notation. These are the two that I'd like to talk about now. These are also really important jury events. The one that we use at the start of the day is this one. So, of course, what will happen, say we're on day 2 of a trial, and on day 1, the jury was impaneled, they were sworn in, they're ready to go, there is a jury in this trial. On day 2, at the start of the day, His Honour might come in the morning. This is the very first thing that happens, and say, good morning. And then there might be some discussion. But of course, at this point, right at the start, counsel. At this point, the jury aren't in the courtroom because, as we said, after any sort of adjournment, even if it's a whole night adjournment, the jury have to formally be brought back in by the judge. So at the very start of day 2, His Honour comes on the bench, he bows, he sits down, he starts discussing things with the barristers. The jury aren't in the courtroom. Now, we need to make that clear in the transcript, that everything that is happening in the absence of the jury. What we do at the start of the day is we use a notation that is different to anything that happens for the rest of the day. We come up to jury events and we click upon resuming, the jury absent upon resuming. So you can see what this tells us in the transcript is that everything that's happening in the morning at the start of the day is happening in the absence of the jury. The jury haven't been brought in yet. Now, at the very start of the day, we use this upon resuming in the absence of the jury notation. However, if say for example, the jury has been in later on, and then we're going to have a short adjournment, so the jury leave. We have the short adjournment. So I'm just going to pop that in. So say we have a short adjournment. And then the judge comes back. Of course, it's after an adjournment. The jury aren't back in yet. So we need to reflect that again in the transcript. What we are going to pop in is this jury absent macro. You can see it's very slightly different. Instead of upon resuming in the absence of the jury, we just have in the absence of the jury. Now that may seem like a pretty sort of meaningless distinction, but it's what you will find in the VGRS manual. So for the start of the day, when a jury has been impaneled, but the matter is just starting and they're not yet in the courtroom, we use upon resuming in the absence of the jury. And after any other short adjournment throughout the day, we use in the absence of the jury. Now that includes the lunchtime adjournment, although that's another point of ambiguity in the manual. So our practice here is to just always use in the absence of the jury after any short adjournment or lunch adjournment. In the manual, there is actually one point in the inner margin examples where they mention that upon resuming in the absence of the jury should be used after lunchtime, but that's never been the practice here. And I've got the official word on that thus far is that after lunch, we just use in the absence of the jury. Start of the day, resuming in the absence of the jury, any other adjournment, in the absence of the jury. There's just one more jury event that I'll mention. And you can see down here it's jury question. Now, in my time at EPIC, I've never had to use jury question, but this is what it looks like. I'll bring it down a bit. You can see here. Oh, sorry. Do that again. Jury events, jury question. Just looks like this. Now, we were mentioning before that actually jury members can ask questions of the judge at any point during the proceeding. What generally will happen is they will think of the question in the jury room. They'll pass a note with the question on it to the tip staff. The tip staff will then give it to the judge. The judge will read it out to the barristers in the absence of the jury. They'll talk about how they should approach giving an answer, bring the jury back in, give the answer to the jury in response to the question. However, this macro is for a slightly different thing. At the very end of proceedings, I'm not sure if it's mentioned in here, it is. At the very end of a trial, just after the judge has given that charge to the jury, so after he said, this is the task you're now going to undertake, these are the important things you have to remember, la la la. At that point, the jury has an opportunity to ask other questions. If it occurs at this point in the trial, right at the end after the charge and before they retire to deliberate, that's when we would use the jury question macro. And there's a section on that in the manual, and I'll just point you to it. Again, it's going to be in section 5. Here we go. So you can see on page 25, we have jury questions during a trial. So that's just those generic questions we were just talking about before the end of the trial. But then on page 26, we also have jury questions during deliberations. And you can see that we select a macro for that at that stage in the proceeding. So just have a read through of that. I just highlight it because it's one of the macros in the jury events. Okie doke. Let me just have a look and see. I've still got about 10 minutes or 15 at the outset. Yep. Okie doke. Something else I might just mention is in regards to impanelment. So I'm going to bring up my impanelment example again. Oh, I got rid of it. Okay, so I'm going to come back up again to the example in the manual of a county court jury impanelment. As we spoke about before, after the jury is impaneled, we then have the formal appearances and the rest of the trial happens. And so we know that a jury has been officially impaneled when they've given their oath or their affirmation. Now, if you were the one, for some reason, doing the jury impanelment, once the jury has taken their oath or affirmation, it's really helpful if you jump into your matter spreadsheet. So say it was this one up here, our old friend Georgina Matter and Robin Taylor. So that's not a good example. I'm going to jump into Zanaga that we were looking at yesterday. Okie doke. You can see I've just pulled up our day 5 training tab, but if we come over here to all of the notes that we had for this case, which were many because it was a really complex one, you can see that somebody has popped in here, jury of 12 impaneled. And in fact, you can see that's there for day 4, for day 3, for day 2, and not for day 1. So what that tells me is that on day 1, there was probably some pre-trial discussion between the lawyers and the judge. And then on day 2, you can see over here, clearly I'm the one who's done the jury impanelment because I've popped my initials in all of them and they've all been typed in the same cut. What I've done once the jury has been impaneled is I've come over here and I've typed into the spreadsheet, jury of 12 impaneled, and I've highlighted it. Now, the reason that I do that is because when the TCs come to make subsequent days in the spreadsheet, they will copy that note across to the next day. And the reason that's important is because for us as typists, if say we're coming onto Sanaga on day 5 and we've never typed on this case before and we have no idea what it's about, we need to be able to see quickly that there is a jury involved. Now, if it was day 5 of a criminal trial, you would assume there would be a jury involved. But every now and again, a jury, for example, might be thrown out halfway through a trial, and then they have a couple of days of legal discourse, and then they get a new jury in. So I need to know as a typist immediately that there is a jury of 12 involved in this case, because when I'm typing my cut, say I go on a short adjournment, I need to know when I come back from that short adjournment whether or not I need to use my jury events, whether I need to do in the absence of the jury when I come back on. So if you're the one who's doing the empanelment, I would really recommend after the jury has been sworn or affirmed, coming over to the spreadsheet to the notes section and popping in jury of 12 or jury of 6, jury of 15, whatever the case may be, empaneled. It doesn't really matter if you don't know exactly how many members have been empaneled. We just need to know that there is a jury there. So when we come into the case blind, we know to use the appropriate macros.